bartend shirtless and doesn't do bat mitzvahs anymore, and really is the host with the most. Loy is one of the finest humans I know, professionally and personally, and he is a licensed agent at Village Real Estate and also a credentialed attorney at Rudy Title, and has been very instrumental in their growth and been a close friend and partner of the Village family for a long, long time. So today's about getting into how the hot dog's made of title and how you can better work together with your title company for successful outcomes. So with that, Loy, you're muted. I'm gonna let you hold, please. He's the greatest showman, my friends. Hold on. You're muted, Loy. There he is, my friend. Start it up straight. Go ahead and start over.
I'm telling you, my technology leaves a lot to be desired, and I'm going to show you that today. Teddy, one thing I need your help with. I've got a PowerPoint queued up. Yep. How do I share that with the group?
No problem. So at the bottom of your screen, you should see a share screen green arrow.
Love it. Got it.
It's going to give you, when you click that, it should give you an option. It should show you your desktop of which one you want to pick. And just like that, Loy is sharing a screen, my friends.
Look at that.
Yeah.
Let's
nice
see.
Work. You can go to your presentation mode and drive it just like you would on the big stage.
Yeah, my F5 isn't working to play, but we'll see.
Go to slideshow. Anybody other playing at home that wants to give him a, there we go.
There we go. Good deal. All right. So hopefully everybody can see that. Teddy, can you confirm you can see me and the screen? Is that right?
I can and hear you well. Yes, sir. Go ahead.
Okay, perfect, perfect. First of all, thank you for a little patience to get started this morning. I am here at the home office on 21st Avenue, and I'm standing at Zach's podium right now because it's got good mojo after the meeting. And what we're going to talk about today are just some of, like Teddy alluded to, what goes on behind the curtain, because there's so much that realtors have to deal with on the front end and throughout the closing for sure. But when the handoff goes to title, especially in the early part of an agent's career, they kind of treat that like a black box. And they're like, you know what, they're good, they're gonna do their business. I don't need to go in that black box. And hopefully a closing is gonna spit out the other side. Today, what we're gonna do is open up that black box a little bit, and so you can start to unpack it so that you guys can better understand and hopefully better describe what a title partner is going to do for you. Now, what I'm going to talk to you about today, of course, I am excited anytime that a realtor trusts Rudy Title with their client. But what we're going to talk about today is going to be true with all title agencies. So it's going to be kind of a generic approach. If you happen to be one of those agents that just uses another title agency, this is going to dovetail well with the work that you do with them, okay? So without further, and one other point before we get started, just a housekeeping issue. I am known for, and I think Teddy will attest, to trying to teach with a fire hose. I will blast you with so much material that you will leave with your head your head spinning. What I'm trying to do today is adopt a less is more approach and encourage dialogue. So if there is any question that you have or something like that, just unmute and ask your question right away. Interrupt me because I want you to think of it while you remember it. Because if you have that question, chances are somebody else out there has the question too. So it's going to be very much dialogue based, and I want to answer the questions that you have, not the questions that I think you have. Okay? Sound fair?
That's
all right.
Loy, as we go through here, if I see questions come up in the chat, feel free, if y'all don't want to forget, and he's mid-sentence, just put them there and I'll make sure to interject those as we have time. And Loy,
we'll do a Johnny Carson, Ed McMahon show. How about that?
The fat guy, it's fine. So do you want me to, will you be able to share your slides?
What's that?
Will you be open to share your slides with you? Great. Okay. Well, we'll coordinate that. And Beth, great to see your beautiful face this morning and everyone who's joined us. So that sounds great, Lloyd. Take it away.
Okay. So first thing is just understanding what is title insurance. When I remember my very first home purchase before I was in this industry, and the chief question that I had when I left closing is, how many freaking kinds of insurance do I need to own one home? Okay. And so for that reason, I've kind of given a breakdown here. Now, I may be teaching behind where you are, but just bear with me a minute so we can catch everybody else up to the same page. So title insurance coverage is retrospective. Now that's very important because it is the fundamental nature of title insurance, okay? And so as the slide says, from the policy effective date, and it's a one-time, one premium policy that covers all owners against unknown perils that have already occurred in the past, okay? So this is the one type of insurance that I can think of that you can buy that covers you not for future perils, but things that have already happened in the past, but you just haven't discovered yet, okay? One time, one premium, because you're not covering unknown things, you're not covering for unknown time or by periods of time. So you just pay for it one time to cover all those things in the past, okay? Now, by comparison, homeowners insurance coverage is prospective, meaning it's typical insurance. It's forward-looking, and it's effective from the policy effective date. So, and it's not, a lot of people think it's effective from ownership, but that's not necessarily true, because for the homeowners insurance policy to pay out, you must have ownership and a policy effective date together in order for that coverage to apply. If one happens after the other, then it's going to be the later of those two, okay? And mortgage insurance, questions about that. If you've been in the industry, you probably realize that that coverage isn't for the borrower. It's not for any party to the transaction except for the lender, okay? And we call that the mortgagee. Now that term gets a little confusing, and that's why I put bank there in parentheses. But the mortgagor is the one who is needing the loan, and the mortgagee is the one who's providing the money in the loan, okay? So the mortgage insurance is always going to be for the benefit of the mortgagee, and it's an inducement to get that lender to lend on a transaction that they normally would not lend on because the borrower can't come up with 20% generally. Now I know that there's loan products out there that are exception to that rule, but that is the general rule. If you can put down 20%, then you're probably not going to need any mortgage insurance, and the bank will be happy to loan. If you can't put down 20%, the bank is not going to want to make that loan unless there's some level of mortgage insurance that they will provide based on the risk, okay? And then home warranty coverage. I didn't used to have this in this conversation, but there was a lot of questions that came up about it, so I've added it. Home warranty coverage prospectively protects homeowners from some of the costs of appliance and systems failures, okay? So it's important to know that. Homeowners insurance, home warranties, they are growing in all kinds of directions because they're all trying to be their own special snowflake out there in the field of other home warranty coverages. But it's important to know that most of those policies are only going to protect systems failures with the house, okay? So if you have a design structure problem, if you have a wood issue with the house, it's going to be very hard to get coverage. If you have an HVAC issue and you have HVAC coverage under your home warranty, then that's an ideal issue to use home warranty coverage for. Okay, so now that we kind of have covered, we've got our arms around the types of insurance that we're all going to run into, let's drill down on the title insurance part because that's what we're here for. So next slide is title insurance, and this really breaks it down into one sentence fundamentally what title insurance is. It is a contract, just like a contract for purchase of sale, but this is a contract of insurance. It's against the loss or damage on account of encumbrances upon or defects in title to real estate. So let's break that down in a couple of different pieces. So title to real estate. Title in the real estate world is a little bit different than title in the automotive world, because in the car world, you know that you have a certificate of title. And in Tennessee, it's the Department of Revenue, Division of Motor Vehicles, that handles and manages the issuance of those certificates of title. If you hold the title, whoever's listed on that certificate of title has 100% ownership. But in the real estate world, title is much more ambiguous, okay? And we know that title it's an idea that you have to develop by having an educated title searcher go and look at the whole quilt of ownership as it relates to that property and then develop who has an ownership interest in it, or more generally, who has an interest at all in it. It could be a lien hold interest if there's someone who has placed a lien against that property, like a mortgage lender or a judgment creditor. It could be a leasehold interest if you have a tenant situation with a property and perhaps they've recorded that lease, which you absolutely can do. So all of those issues come into title. When you, every law student throughout the United States, they have to take property law as part of their law school curriculum. And every law school professor, I believe, probably uses the same analogy when they, in the very first class, and that is title to real estate is not like one log that you can pick up and say, by God, that's the log. It's a bundle of sticks. And when you have the vast majority of those sticks, we'll call it all of those sticks, then you have what we call fee simple title to the real estate, okay? As you own that, you can choose to hand out some of those sticks. Like when you purchase it, you might have a mortgage lien, so you would hand out one of those sticks to the bank so that they would have a lien hold interest in the property, okay? So when you're thinking about this sentence right here on our screen, a contract of insurance against the loss or damage on account of encumbrances upon or defects in the title to real estate, it's important to think about whenever you hear title of real estate, it's that bundle of sticks. Okay, and it is a contract. It's a contract that says the insurer will pay if certain things happen to the property. And of course, we know that all insurance contracts are wildly complicated because they want to provide effective coverage but limit their risk. So let's jump over and look at the next screen. So this is the screen that most people find the most helpful, okay? Because this is the types of perils covered. And this is what clients ask. It's like, give me an example of when a title insurance policy is going to be a benefit to me, okay? Now, all mortgage lenders know this, and all mortgage lending underwriting departments know this. And that's the reason that they require a lender's title policy before they'll even make the loan, because they want to be protected against all of these things that are very difficult to discover in a title search, but do over the course of many, many transactions happen quite frequently, or frequently enough to warrant the insurance. So number one is forgery. And I'm gonna have a couple of examples as we go along of these things that, you know, are a little more complicated to understand. Forgery is pretty easy. Somebody forged a deed and recorded it and then sold it to you. You bought it for value, and then that seller moved off to the Virgin Islands. Then title insurance is going to be really helpful to you to back you up and guarantee your ownership. Now, how much is that title insurance company going to spend to defend your title or to purchase title for you? They're going to spend up to the maximum insurable value is going to be the price that you paid for the home, okay? Under a loan policy, it's going to be a little bit less usually because it's going to be the amount of the loan. So if you buy a house for $400,000, the lender loaned $300,000, then you as the owner are going to have coverage for $400,000, but the lender is only going to have $300,000 worth of coverage. Number two is fraud. So let's say Granny's on her deathbed, and right before she passed away, grandson, he committed some sort of fraud, and as it relates to other heirs, then it would cover that. Fraud and forgery kind of go hand in hand in these title insurance coverages. Undue influence. Think about Granny back on her deathbed. If grandson exerted some kind of undue influence in the last week of her life, and he said something like, you know what, I'm going to stop feeding you. I'm only going to feed you if you sign this deed right here. And she signed the deed because she wanted to be fed. That's, you know, classic case of undue influence. Duress. You can have emotional duress over someone. In Tennessee, you cannot have financial duress. And a lot of people feel financial pressures, and they go into court and they try to argue that those financial pressures was the emotional duress that they have. But courts have consistently upheld that financial duress is not real duress. A classic case of duress is you hold a gun to someone's head and you tell them to sign this deed or you're going to kill them. Incompetency, if you have someone under the age of 18, they are by law incompetent. So if you received a deed and the deed was signed unknowingly by someone that was under the age of 18, then your title policy will guard you there. Or if you have an elderly person or person that has developed limited mental function and they are judged to be incompetent, and the deed is invalidated, then the title insurance will cover you there. Incapacity, it's very similar to incompetency. Impersonation, that's very similar to fraud, because if you have someone show up at closing, we actually had this happen without revealing specifics to the transaction. We had a transaction where a gentleman showed up with his wife, but his wife didn't have an ID. And as it turns out, he and his wife were actually separated, and he showed up with his girlfriend who purported to be his wife and tried to sell the property to abscond with the money and get it out of the divorce marital estate. But of course, we require an ID to close, so that was caught. There's failure to authorize the transfer or conveyance. That kind of speaks for itself. Improperly created, executed, witnessed, sealed, acknowledged, notarized, or delivered documents. So you might, and this kind of relates to the next one too, but an example of that would be a power of attorney that was improperly executed, witnessed, or sealed. Now, as of about 10 years ago, we have a new state law that protects us a little bit that way. But let's say you have a property that you bought 12 years ago, or the seller that you're buying it from bought it 12 years ago, and they discover that in that deed, it was improperly notarized. Someone could attack that and say, this transaction is invalid, and bankruptcy trustees are very well known for doing this. Documents executed are falsified, expired, or otherwise invalid powers of attorney. So powers of attorney can be revoked, and it's very hard to determine when those powers of attorney are revoked. So that's why this coverage exists, and that's also why most title insurance underwriters, they don't want to rely on old powers of attorney to facilitate transactions. Once you realize powers of attorney that were revoked, they have to cover those under title insurance. You understand why title insurance underwriters want a current power of attorney. They want one created by the title agent. They want it to be limited and specific just to this property, because that gives some extra assurance that, yeah, the person who's giving this power of attorney, they really do, very close in time to the transaction, they want the person with the authority to sell this property for them. Documents not properly filed, recorded, or indexed in the public record. That covers all the mistakes that they may make down at the Register of Deeds office. Defective judicial or administrative proceedings. Let's say that a divorce was challenged, or a divorce ruling was challenged that vested title completely in one party or the other, one marital spouse. After closing, that was challenged. Well, the title insurance would cover you as to any defect in that judicial or administrative proceeding. A divorce is judicial in nature. Administrative proceedings are like metro planning, things like that, zoning. And then 13, lien of real estate taxes or assessments imposed on the title by a government authority, due or payable, but unpaid. So this is a classic example of the thing that title insurance pays out the absolute fastest. Because if for some reason prior taxes were missed by the title search, or they were caught in the title search and not collected at closing, and closing proceeded, then the title insurance underwriter, they pay those out the fastest, because there's really no arguments about taxes being due. There's no arguments about whether they were paid or not, and there's no arguments about liability. A lot of these other things, they'll do a lot more investigation of. They'll hire, they'll coordinate claims counsel to defend these issues, and sometimes they'll hire a litigating attorney to work on these issues to try to remove the issue without just writing a big fat check. But they have, very complicated systems where they'll determine whether they, just write a check or hire counsel. But taxes are one of those things that they just always write a check on. So for example, if you bought a house, it being our 2020 tax year, if you bought a house right now, 2019 taxes were never paid, and the closing occurred, and 6 months later you get a letter from the taxing authority here in Nashville saying that they're going to take your home if you don't pay those back taxes. Well, then you just get in touch with your title insurance agent. They coordinate with the underwriter and they get you a check, or they actually pay that right to the county for you to remove the lien. Unmarketable title, that'll be title that is so unmarketable that it is chiefly uninsurable. And that's almost the subject of a whole other class. What is unmarketable title? And it's a complicated patchwork, but it's generally, the general idea is the title is so frustrated with problems, or even a singular problem, that you cannot sell it for what would otherwise be the reasonable value of the home. And no right of access to and from the land. So that'll be, is the property landlocked? And they will make sure before closing there's an easement and all those things. So that is probably, I don't know, you guys might give me some feedback and tell me that that's your favorite part of the presentation, just having these list of things that title will cover for you. And like Teddy and I talked about earlier, you're going to get a copy of all these things so you can incorporate these into any listing or presentations that you have with any client for that matter. Probably buyer's presentations more than anything, just to let them know what they're going to be covered for. So what does the policy language look like? I would imagine that most of you guys have a title policy, that you own your own home and you received a title policy, but maybe you've never looked at the title policy language. Well, I think the critical piece of it is what I've got on the screen right now. Subject to the exclusions from coverage, the exceptions from coverage contained in Schedule B, and the conditions and stipulations, the title insurance company as of the date of the policy shown in Schedule A against loss or damage. So what that means is, and look at the red parts to help with the breakdown, the exceptions from coverage contained in Schedule B. Schedule B is going to be all of those things that are discovered in title, but are going to be an exception from coverage that the title insurance policy will not pay for, okay? So an example of that would be, if you closed right now, a Schedule B exception to title would be taxes for the year 2020, which are a lien on title, but not yet payable, because that bill doesn't come out until October, okay? Another example of what you might find as an exception to coverage would be a known easement on property. So for instance, if you're buying property and there is a farm behind this property and they have a known easement with a driveway to access that property, that would be an exception to coverage. But for that language being on Schedule B in the policy, even if it was a known driveway, the title insurance company would have some risk if they didn't put that in the Schedule B, okay? And then Schedule A talks about all of the coverages. So that's not the exception. It describes Schedule A, who is covered, the amount of their coverage, and the date and time of their coverage. Every title policy not only has the date of the effective coverage, but they'll also have the time because and the time that we use when we produce it, the original policy is always going to be the time that the deed was recorded, okay? So that's the policy language. Let's go over to look at just quickly coverage by timeline. And I think you guys have this, but I created this fancy little graph, so I had to include it, right? Because I had it created. Title insurance is retrospective, so that's going to be on the left-hand side of your screen. And down below that, you'll see incident must have occurred prior to the policy date to be considered covered. Now that sounds pretty basic, knowing what we've already talked about so far. But I'll tell you, many, many, many times, people get wrapped around the axle of title issues that come up after closing that the title insurance company had no way to discover, because we don't have crystal balls like most of you, there is no coverage for it. So for instance, if you buy a house and you have title coverage, and then a neighbor starts using part of your land for the next 20 uninterrupted years, you probably remember from your real estate classes that they would have a case for adverse possession. But since that arose after the date of the policy, there would be no coverage for that. Now, look on the right-hand side of your screen, you'll see after the date of policy, you have your homeowner's insurance, and that is prospective. The incident must occur within the policy period to be considered covered. And I'm going to add one other proviso to that. Incident must occur in the policy period and during the period of ownership. Because even if you have a policy, if something happened that you do not own that property, and this is true with automobiles too, they will not pay. You have to have a policy that covers it, and you have to have ownership before they will cover under property and casualty insurance. Okay. So this is also kind of fun for you guys. So this is where we're really opening up the box a little bit and seeing what goes on. It's almost like the life of a file inside a title company. These are all the things that we do that many of the times we don't even talk to you guys about. So quickly we'll run through these. What title companies do for typical title rates. So we do a title search. That's where we hire someone to go out and search in the public record and produce an abstract of title for us and send that back to us, letting us know everything that was found in the public record. Now, what we do is some title companies do their own searching. We don't. We hire our underwriter to do that searching, which allocates the risk of that title search process to the underwriter. So that means if there's a problem with the search, the title insurance underwriter will still cover that because they messed up the search. So that kind of provides one additional benefit to the title policy holder if they close with Rudy Title. So it's kind of helpful if you want to mention that to your clients. If there's an error in the searching, because we're all humans, you know, then that will be covered too. Then prepare the commitment for policy. What a commitment is, it is a promise, a written promise to produce a final title policy after closing, okay? So the commitment is what everyone relies on before you get to closing. In a commercial deal, if you've ever been involved in a commercial deal, you might know that most parties hire attorneys to really comb through all the documents. One of the things that an attorney will do that represents a client in a commercial sale is to comb through the commitment and mark up the commitment, and they are describing what they want the final policy to look like. Because on a commitment, it's going to have a whole lot of requirements that will be taken care of in a typical transaction. So those things are going to be struck off like a checklist as the title agent takes care of those things. And so when they mark up that commitment, they will strike those things off and indicate that these are things we expect the title company to complete, and we do not expect to see these on the final policy as exceptions. Then number 3 is the biggest part. It is the real wild card of what we do. So after we've prepared the commitment for policy, remember that's our checklist, then we have to start clearing the liens and encumbrances. So the easiest transactions are ones where we discover that the seller owns the property free and clear, there are no liens, and there are no encumbrances. But that's pretty rare because most sellers at least have one lien, and that's a mortgage lien, right? What we are discovering is there's a growing number of encumbrances on title as inventory shrinks, because we're finding that, and you guys are probably discovering this in the marketplace too, as our supply of homes gets less and less, these homes that are title challenged are coming out of the woodwork because finally they might be worthwhile to wrestle with all these problems, be they inheritance issues, maybe you had a decedent to the property. Heck, we had one just 2 weeks ago where property had stayed in the family, but it was titled to someone who died 2 generations ago. So we have to do a lot of probate work in order to get that one prepared for closing. So usually what we do, and when we get to the clearing liens and encumbrances part, there are some liens that we can discover that are based on our skills and experience. Those are liens that are just going to be cleared up. We've coordinated with other parties. We've got commitments that they're going to provide the necessary documentation. We don't even communicate those to the agent or the client usually. And that's what goes on behind the curtain. And sometimes that comes back to bite us. because in our professional judgment, we may decide that it's not going to hurt us that bad, but it actually ends up becoming an 11th hour problem. And that actually happened with one of Teddy's closings about 6 years ago, and we had an 11th hour problem. And what we have decided to do is to continue that process of, kind of keeping problems that are likely to be resolved, wildly likely to be resolved, to ourselves. We keep that behind the curtain because we don't want to start piling problems on clients and agents when in all likelihood those are going to be resolved. So that's the clearing liens and encumbrances part, okay? We coordinate with all parties. You guys know that piece. We prepare a settlement statement. You know that piece as well, too. A couple notes on preparing the settlement statement, and we'll talk about this in terms of setting expectations in a little bit, but make sure that your client knows. There's some clients out there in the marketplace that feel like they're not getting good service unless they have a settlement statement to review 6 months before closing, okay? As soon as they sign the listing agreement, they want to look at the mathematics of the transaction. And you and I call that a net sheet. And then they want that net sheet to be penny correct all the way through closing. Okay. Now that's a little bit of an extreme example, but there are clients out there that have expectations that are getting closer and closer to that. What we know being in the industry is what typically happens is on the buyer side of a transaction, they get a peek behind the financials that are relatively reliable 3 days before closing. On the seller side and on the buyer's side, they can be much more reliable if they receive that the financials 24 hours before closing. And I think if I asked for everybody to raise a hand for a transaction that they had that they didn't see the financials until they got to the closing table, I think everybody would raise their hand. Because there are times that we have things coming together so last minute because we're trying to wrangle a lot of cats to get to the closing table. Sometimes it happens that way. I try to apologize every time that happens at the closing table because our goal is to make sure that those financials are agents and parties 24 hours before closing. We also have to prepare underwriter required docs like affidavits and different statements that they must sign based on what we discovered in the title search and liens that that became an issue. For instance, there may be a judgment lien out there with a close name, but we have discovered that the Social Security doesn't match, okay? So that's a pretty reliable indicator that this is not this party's debt. It's not their judgment debt. So we will just have that seller sign an affidavit saying, I know nothing about this debt. And an affidavit is nothing more than a written sworn statement under oath, okay? Written sworn statement under oath. And of course, that has to be notarized too. And we have to receive and integrate the mortgage. That's at the bottom of that first column. That's a huge part of it. Whenever you have a buy side with a mortgage, 80% of the documents are going to be mortgage documents. And if you've ever had a closing where there is, where it's a cash transaction, you know that it is as quick, easy, and brief as a seller side transaction. It usually takes about 15 minutes tops, as long as everybody's comfortable with the math as laid out, okay? But those mortgage documents, that's what usually takes as long as or longer than the title process, usually about 20 to 30 minutes to go through just the mortgage documents. Of course, at the top of the next page, conduct the closing. That's our favorite part, right? That's where we have the finish line for you guys mostly, but that's not where our work really ends. We have to obtain funding from the lender after the closing. We have to disperse all the funds and payments. Oh, and by the way, I have a personal mission that I want you guys to help me with. There are two words out there in the English language that are so close that people mess them up a lot. And I'm reaching over to grab my coffee so I can look studious drinking coffee while I talk about this. There is disperse with a B and disperse with a P, okay? And those are different things. And as we're using talk to text and as we're typing fast and, just kind of moving through communication pretty fast, sometimes those get mixed up. But I want you to remember disperse with a B only applies to money, like a bank. You can remember B and bank, okay? And disperse with a P is what people do. Like police may go in to disperse a crowd, but you only disperse with a P people and things. So remember, P for people, B for bank, and you won't ever mess those things up, okay? So that's a big part of what we do, and we have a lot of money. At any time at the end of the month, Rudy may have something upwards of $20 million in our escrow account during those busy times that we are responsible for accounting for down to the penny. It's not horseshoe rules. It's not close enough. It's good enough. They did a good enough job. We have to account for every penny and make sure it gets exactly to the proper party. So that's why you may hear me say, you know what, your client brought a cashier's check to closing and they got it just a little bit wrong. They were 2 cents over. So I must cut a 2-cent check back to your client, and I will beg them to cash that check instead of framing it just to laugh about it for years, because we have to do something with that money. Provide closing documentation to necessary parties. That's part of the normal game that we do. And of course, you know that we not only give documentation to you guys as the agent to make sure that you get through compliance, but also to your clients as they leave. And we provide that either in printed format or on a USB drive. For those of you guys who've been around Rudy for a little while, you know that we were the first in the industry to offer closings on a CD back when CDs were, you know, kind of commonplace. And you remember laptops used to have an optical drive to them, but more and more, these laptops don't even have CD drives. So about 4 years ago, we made the decision to adopt a more expensive approach, and that is to provide USB drives for all the clients, because I think there's not a computer they're making right now, maybe some tablets, but not a laptop they're making without a USB drive. We have to record the deed and other recordables. And recordables, I know that sounds a little redundant, you record the recordables, but recordables is like this big basket term that we refer to as anything that needs to be memorialized in the Register of Deeds office. Okay, so typically that's the deed and the deed of trust. However, it could be more complicated. Like for instance, I had a transaction last week with a wildly involved easement. And the easement was signed by the seller. So that seller granted easement before the transaction. But we just saved the recording of the easement until concurrent with the transaction. But the order of recording was, we had to make sure the easement was recorded first. The next thing to be recorded was the deed. And then the third thing to be recorded would be the deed of trust, or the mortgage security instrument. And the order of recording of those things when they go off to the Register of Deeds office is very important. Third from the bottom there is perform a bring down or second title search after recording. Now, this is way behind the curtain. A lot of people don't even realize we do this. But as soon as we get everything recorded, to check our gap between the date of closing and the date of recording to make sure nothing happened in that range, we will perform a bring down. Some people call it a date down of title. And all that is a second mini title search where we just search that little brief period from the date of closing through the date of recording to make sure that nobody ran down to the Register of Deeds office and recorded a lien, like a judgment lien against the seller. If that happened, that's one of the things that a title policy would protect a buyer against, because that is what we call gap coverage offered under a title insurance policy. Now that gap coverage is very important right now, because what do we have? We have the COVID epidemic happening to us right now. So, and we experienced this in Sumner County, where early on during the COVID epidemic, they shut down the Sumner County Register of Deeds office. So what that does to us in the title insurance industry is that extends the period that extends the gap before recording. So from the date of closing until the date of recording, that just grows that period of time while that Register of Deeds office is closed. Now that tells us that there's also nobody else recording anything like liens in there, but it's also building this pent up period of time where things could be accumulating. And then when they reopen the office, we want to make sure that we get down there first thing on that day they reopen and get our stuff recorded to minimize that gap issue. Of course, we prepare the final policies, and then concurrent with that, issue the final policies to the owner and lender. And that's a physical mailing that goes out to the owner and lender. So as you know, if you have purchased property after closing, usually about 60 days, you're going to receive your original warranty deed, and you're also going to receive the owner's title policy in the mail. The lender receives a different package. The lender receives their original security instrument, which is the deed of trust, and then they're also going to receive the lender's title policy, which you will recall is not for the purchase price for the home, but it's of their loan amount. Okay? So that's what we've got there for what title companies do for typical title rates. And I think this page right here and the perils that are protected are going to be the biggest takeaways for you that you may choose to include in your own presentations. Okay. Teddy, I see that you popped back in here. I want to ask you, is there anybody that's asked a question or maybe a question that you've thought about during this process?
No, I would love, Sylvia had mentioned she loves the disperse versus disperse, and I like that as well. Mm-hmm. No, this is great. That's obviously this is 2.0 for everybody. And while I know sometimes it may seem dry and you may not need answers to these or need this level of understanding, what I've learned and I shared with someone I was coaching yesterday is, our role is really to be prepared for the 1%, right? They can teach themselves, and this business and most things are turning much more transactional. I want to make sure my Uber driver knows what to do if we get in black ice, right? So like the rest of it I can do myself, but if I'm working with a professional, that may be a stretch in the Uber scenario, but is when I don't ever want an attorney, but when I need one, I don't want to use my friend. I want to use the best. And so it's kind of like for me, when I partner with a title company, I need them to know all the nuts and bolts. And also that I know how to ask the right questions and to be that buffer between the clients. So these things are really, really important. And for those that I'm looking forward to moving into some of the pieces you're about to cover now, because these are the things that really do affect us as realtors and have an enormous effect on the smoothness, if you will, for lack of better language, and effectiveness of how the process goes. So feel free to chime in with any other questions as we go through this too, or if you have other tips that you'd love to share, we'd love to hear them.
Oh my gosh, yeah. If you have a tip that you have developed that works out for you, I would love for you to share that with the group, and I'll amen it probably. But let's talk about closing date, because this is something that there is a psychological compulsion to choose closing dates that are in the last week of the month. We know that because statistically, I think everybody's been in the title agencies at the last day of the month and you're like, oh my God, I can't believe this. This looks like a zoo. If you're closing with a title company that has a good book of business. At 21st Avenue, Rudy, it can be exceptionally a zoo. What we discovered is at the end of last month, our business was going to be so robust that 21st Avenue, they set up tents in the parking lot. We had a valet parker there in the lot to get everybody parked. We brought in some teenagers to help with serving beverages in the lobby, just to try to keep everybody entertained until we got them into a closing room, So we did everything short of open up a Chuck E. Cheese for the kids out front.
And the bounce house was for the adults.
That's right. Yeah, that's right. Because sometimes when they learn their interest rate, they need a bounce house to just ricochet off for a minute or two. So typically busy days, Fridays, of course, are the busiest day of the week. That's true for us. It's true for the wire departments and the Federal Reserve. So that's something to think about too. Anytime that possession is an issue, you want to avoid Friday afternoon at all costs, because you can cost yourself not just one afternoon, but a whole weekend. And as you know, clients that have the weekends off, they love to move on the weekends. Last day of the month is very busy. And if you join those two together, then you have the last Friday of the month, and that's kind of like a double threat right there. So for instance, last month in June, our last Friday of the month was not the last day of the month. And so that helped split up the business for us a little bit. What we are looking forward to in July, this month, the last day of the month happens to be a Friday. So we plan on it being exceptionally busy, even more so than June, if you want to close on the last day of July. So this is your opportunity to look at all your contracts in your pipeline right now. If they're closing the last day of July, you might want to retool that and talk to your counterpart about getting that closed. And then the last typically busy day is because there are people people who abhor agents who abhor closing on the last day of the month so much that they are picking the day that is equidistant from the two ends of the month, and they want to close on the 15th, because that's as far away as you can get from the ends of the month. So what we're finding is we have this second spike in business that happens around about the 15th. So that leads us to the next major category down there at the bottom of the page. Usually ideal closing days for best service. Now, bear in mind, holidays are going to change this a little bit, but usually the second and third week of the month. So at the end of the month, we'll hit a spike, and then we'll go into the first and second week of the month. And then toward the end of the second week, we'll have the 15th that'll pop up on us. And then the third week of the month will be good. And then we'll run into the fourth week where we start really, really building a lot of steam during the fourth week. One thing that you guys probably want to think about in terms of your business, well, let me say it another way. One thing, because of the nature of your business, you probably haven't thought about is every title company, in addition to purchases and sales, also manages refinances that typically aggregate around at the end of the month as well. And that's because if they do a closing toward the end of the month, most mortgage lenders do that because they get to pull a magic trick out of their hat, and that is to keep their clients from having to make a payment for 2 months. If they get it very close to the end of the month, then they can keep their client without a payment for 2 months, and that's generally kind of fun for the client. They feel like they've done their clients a service, and the clients perceive that too. So know that during that last week of the month, subject to the rescission periods of 3 days, there's going to be a lot of refinances coming on. So that's usually going to be about 3 business days before the last day of the month is when we hit our refinance peak. Okay. So now you've got some guidelines to think about when you're trying to, especially if you have a transaction that needs a little extra love and care by the facts of the transaction or the clients involved in the transaction, then maybe you do want to try to pick something that's like, the 8th, 9th, 10th of the month, or maybe the 18th, 19th, or 20th of the month, in and around there. Then maybe dodge a Friday too. One other thing I want to say about that, choosing your closing date, that's a concept I think we've addressed pretty good, but choosing your closing time. When agents get in the business, what we see is they give their clients the entire spectrum of the day that they can close. And they just ask their client, when are you available? And then that client inevitably says, well, I'm available after I get off work, or I can take off of work an hour early. So newer agents tend to have clients that close like 4 or 5 in the afternoon until that agent discovers that there are funding and possession issues, and usually the transaction isn't going to settle until the next day. So the best transactions are those that happen, as far as funding and possession in the same day, are going to be those that happen before 1 p.m. each day, okay? 1 p.m. each day, because that gives us, all other things being a fairly typical part of the transaction, even with a split closing, that gives us enough time that we can get those funded. There are a few other title companies in town that we deal with that are notorious for withholding funding. They just slow walk funding, okay? So if they represent the buyer's side of the transaction, Rudy has the seller's side, and we close at 1 p.m., there may still be an issue in getting that funding in. So to be even safer, you might want to try to close in the morning. Now, most of our seasoned agents that do most of the business in Nashville have discovered this, and that's the reason we do a lot of closings in the morning. But the value of funding it that same day far outweighs having to deal with the congested nature of the office. That's a minimal point compared with getting your client's possession the same day. And then we've got potpourri here. These are just a couple other shotgun issues that I wanted to talk about. So escrow agreements, these are issues that cause us a fair amount of stress on the title side, some of them. And so I want this to be like an open communication and a conversation with each transaction, and not just like a title company airing of grievances that you guys get to listen to for the next 4 points. But when you have, again, with newer agents, a lot of them learn about this little tool that's in their toolbox, which is an escrow agreement. And they start pulling it out on every transaction, because whenever you go do a walkthrough, there's going to be something wrong with the house. If you look long enough, you're going to find something that was otherwise not discovered. And what a newer agent will do is just try to do an escrow agreement for everything. And what I would love to see happen more often, and what typically happens once agents get used to the escrow agreement being a tool but not a compulsion, is having a discussion with the other agent, setting expectations with your client before you get to closing. It's like, you know, you're not buying a new home, you're buying a used home. So I don't want you to have the same level, you know, I don't want you to have a sharp pencil that you would have if you were buying a new car or a new piece of furniture or having a new appliance delivered. Because if there's a scratch, then yeah, you want to deal with it. But if you're buying a 20-year-old home, you're going to find a scratch in that home somewhere. And that's kind of what you're buying. And helping them to have that expectation is really super helpful in avoiding escrow agreements for both you and I. But sometimes escrow agreements are needed. Teddy had an example years ago of you buying a lovely home with a beautiful area rug in the middle of the living room, and you want the living room rug, but the seller doesn't want to sell it. It was grandma's living room rug, so they take it when they move. You do the walkthrough, and you discover that grandma's rug was hiding a terrible flaw, which is a huge gouge in the living room floor beneath it. And that's when the negotiations start, okay? And you start figuring that out. That's probably a good example for an escrow agreement, because it was something that was not discoverable. Because I think in Teddy's example years ago, I don't know why I remember this so much, Teddy, but I sure do. In Teddy's example years ago, there was a grand piano also sitting on Granny's rug that prevented people from being able to look at that. So the first opportunity to discover it is in final walkthrough. We know that final walkthrough is not to discover new issues, but it's only to verify things that have already done. The exception to that statement is things that were undiscoverable because they were obscured by the seller or impossible to discover based on the arrangement of furniture and things like that. Hopefully you're not going to find that Granny's rug is going to reveal a trap door in the floor or some, pit or something like that. It's just something minor, but
another common one with respect to rugs is discoloration of the floor. So you just need to be able to pick up a corner of it, but be very mindful of rugs near windows that the wood can discolor, and pretty significantly. And so unless your buyer is prepared, so as the buyer starts loving the home, I'm just kicking up the corner of the rug with my foot and just doing little things like that to see, but it can only help you to try to address those things on the front end. And, it's typically, my experience is it's not refinishable floors. They're pre-finished kind of cheapy floors. And so then some considerations need to come in. Doing that always works better than trying to get it done on the way to closing, which I want to just add to this with respect to escrow agreements is how you schedule your walkthroughs. So doing your walkthrough the hour before closing to check for repairs and their stuff being out is not best practice. I would suggest a 2-stage walkthrough. Do one in advance as far as you can with their things out. If they're not moving till the day of, then do one in advance confirming all the repairs have been done. Ideally, you'd want to do one when their stuff is out, which would hopefully be the day before. But if not, I always do one the hour before closing to check. I turn on all the ovens, flush all toilets, check under all cabinets to make sure. The last chance to make sure there's no new defects or prior that weren't seen before they cut the check.
That's good, Ted. And pee stains from animals.
Big time.
Or humans.
Or humans.
Just pee stains in general, yeah.
It's been a tough couple months for everybody. I mean, let's just face it. Maria, we're going to get to your question. I'm going to come back to that at the end here, so sit tight.
Okay, so delayed closings. That's something, that does happen. Sometimes it's the walkthrough. If you have been around Village long enough to remember Bobby Noreen's big point is she doesn't really like escrow agreements. She doesn't like pre or post closing occupancy. She thinks the best opportunity to get this stuff done is before closing, And so if there's a significant issue, a material issue, whatever that is in your judgment, then perhaps delaying the closing is going to be the best way to do that. Now, nobody's ever excited about that. We're not excited about it in title, but sometimes it's an effective approach. What we find is delayed closings are generally not the product of a realtor or a title agent. It's usually the product of a lender, and I'm just going to go ahead and say it, it's a shoddy lender that your client has fallen in love with and they've brought to the table, much to your chagrin and mine. But you know, they were perhaps the first love before they fell in love with you or I. So we know that we just kind of have to deal with those and move on and hopefully make some suggestions earlier. But delayed closings, especially if it's a national mortgage warehouse without real people behind it, we get delayed closings all the time for those mortgage issues. Third point, remember who is the negotiator. I think that I've looked at the roster of everybody that's in this, and I can truthfully say that I'm preaching to the choir, but I want my choir to help resonate this with everyone else, especially if you mentor a new agent. And that is, just because you have moved into the contract to close phase does not mean that the title agent is responsible to negotiate and communicate negotiations from that point forward. Everybody here in this group is really good at remembering that the title agent is just there to memorialize the negotiations that have already occurred between the buyer and seller by their agents. And I can privately, I'll pull you guys aside and we'll have a cocktail and I'll tell you about some of the disaster stories where, you know, there's some agents that are truly not agents the way I would describe you guys, but they are commission collectors. And they, once it's under contract, it's not their problem anymore. And, you know, well, there's a problem. Title should be working this out. Just call the other title agent, you know, work that piece out. Setting expectations early. That's something that almost everyone in Village does well. It's one of the reasons I love the organization. It's been true for years and years, ever since my first involvement back in 2012. But setting those expectations early is just letting your client know about, for instance, escrow agreements. When would they be good to use? What can they expect going in? What's the expectations for when you're going to get your closing statement? What's your expectations for when the title company first reaches out? And if you guys need any help in tweaking your presentations, you know, feel free to send me the presentation that you guys are using, and I might be able to, you know, add a couple points in that may give you guys a little bit of an edge. So, and I'm happy to do that for you if you have like a PowerPoint presentation for listing or selling. And that's really what I've got right there. I've got questions is my next slide, which is completely worthless. And so I'm gonna minimize or stop my screen sharing if I can manage this technology.
There you go, perfect.
More faces, yeah.
Maria has a question. She said she has a client who wants to change his property to an HPR.
Oh, yeah.
Wants to know how would that affect the value of his property, and that could be open for a lot of interpretation, but we can chat a little bit about that. But if there's anything, Maria, and if you want to chime in as far as more logistics of what is going into changing something into an HPR, and is that possible? I've never heard of somebody wanting to do that.
Yeah. Well, I'll tell you, there's 2 or 3 different approaches that you can take with this, Maria, and it depends on the current nature of the property, okay? So if it's undeveloped land, converting into an HPR, that happens fairly frequently, you know, and that's kind of what we think about as just a development of a to-build lot, most of the time to-build. You can also go in Nashville and find an existing duplex, okay? And in that existing duplex, you can not tear anything down or build anything new, but do an HPR construct on top of that existing duplex, because all an HPR overlay does is make what used to be only ownable by one party with one tax map and parcel. It converts it so now each dwelling has its own tax map and parcel and can be sold to different owners. Okay, that's all that a HPR PUD does, because that property is already eligible for 2 dwellings. After the HPR, it still only has 2 dwellings, okay? Whether it's developed that way or pre-existing that way. So, so if there's an existing duplex, you can do it that way. And I think it's there's an interesting little money machine out there. If you can find a property with an existing duplex and then figure out a way to put a little bit of lipstick on it and then make it individually ownable or alienable by 2 different owners. And we can help out with that. What does Rudy charge for that? $8.99, or in loose conversation, $900 is what we charge. And, if you can get, several thousand or tens of thousands of extra dollars just by selling them to 2 different parties, so it becomes primary residence material rather than investor material, then, that's probably worth a $900 investment to make all that happen. And usually you're going to have all that math already worked out before you ever commit to the $900. There is also a survey requirement though. That's what $900 is what Rudy charges. And you're also going to have to contract with a survey company because they're going to have to provide us at Rudy with a site plan. And if you've looked at an HPR, you always know that that's an exhibit. It's usually exhibit B to the HPR. And that's just going to be a 1-page document that is an exact drawing of the land. It's going to show private elements, limited common elements, and sometimes even purely common elements that's usable by both parties. And then there's a third category of developable properties, Maria, and that is a property that has 1 house on it currently, but a large enough portion of an existing yard that you can drop another house into. We are finding that sometimes that's to the side. In the most ideal situations, you kind of have a lopsided lot where they've pushed the house all to one side. But more often than not, we find that gap or the yard space that they want to use for the HPR is in the rear of the lot. So there's a lot of things that you want to do. And I would say the first step, Maria, if there's going to be any new construction go on as part of this HPR, whether it's a raw development or a +1 development where you're adding on to a lot with an existing home, you want to talk to a surveyor first because that takes the longest, and they are going to be the most effective at discovering any issues that are going to prevent the HPR from happening. For instance, if you have a lot where the house is up front next to the road and it looks like, yeah, I can slide a little driveway down here. Perhaps there's alley access off the back. We can get access to this and we're going to put a house down right in the back. But unbeknownst to you, because you haven't done a title search, the same way that a surveyor could do the search, there's a sewer easement running exactly through the backyard diagonally that would prevent that build. And that's something you definitely want to know about before you engage Rudy or a title agent to do the development docs. You just want to learn about that during the survey process. Okay. So hopefully, Maria, that answered your question. That's about the 3 different categories that we would see, an HPR used. And I'll give bonus points to anybody that takes my little money machine that I talked about with duplexes and runs with it. And you can buy me drinks. That's all I want.
Yeah, that's a good one right there. Thank you so much.
Yeah, no problem. No problem. Why is it that Maria's accent sounds so much better than mine?
It's the best. I love it.
No, I recently discovered, this is just completely offline. This is a look behind Loy's curtain. I did some genealogy work and I recently discovered that I'm an 8th generation Nashvilleian and that my first ancestor moved here from North Carolina right after the American Revolution, before Tennessee was a state. And they settled with, like John Donaldson and all them, but they settled in Whites Creek, Tennessee. So if you ever go up to Whites Creek, Tennessee, you're going to find Kearney Road, you're going to find Kearney Creek, and a big Kearney graveyard up there. So,
oh, wow. What did you use to do your genealogy work?
Well, funny story is, I was asked to do an easement for a guy named Gene Kearney. And the
It's quite funny because it's a nice transition. I did want to talk about easements before we log off here. I know we're going a little long here for those that want to log off. But yeah. I did want to just touch on easements with respect to stuff that you all deal with and work with, and anything you could be doing on front end to be mindful of that.
Yeah. Well, just real quickly, Miss Gene Carney needed an easement where he wanted a formal access to this graveyard, which is the Carney graveyard, because he takes care of it. And it turns out it's my ancestors. So, yeah, it's pretty wacky. But let's talk. Wow, you choked up, man. You really.
Easements get me. You get me every time.
I'll tell you. I'll take you to the graveyard. It'll really get you.
Anything about easements that we could be doing on the front end to try to minimize the excitement? I mean, obviously in listing agents, just even asking the question, because it's something sellers don't think about, right? They're not reading the paperwork and they're not, so you need to really ask specifically, are you aware or possibly aware of any easements that this property could have? Somebody owns it. Do you know if your fence is on your side of the property? Could that be easily found, or things like that?
Yeah, so fences, especially on HPRs, have just become a hot button issue. And remember, if you can choose to put a fence anywhere on your property, and that doesn't mean you've given away land, okay?
Or that you own that land or have rights to it or any of that.
Correct, yeah. But over time, we know that adverse possession can have other issues related to that. So if you set your fence 1 foot inside your property and for 20 uninterrupted years, you ignore that land outside the fence, don't mow it, don't do anything, and the neighbor consistently takes care of that land, cultivates it, tills it, he's got his garden weasel out there in the whole business, then he may have a claim if he has excluded you from that, especially if he puts up that fence that pushes, your access to that land away. So you want to keep up with that. Now, the truth of the matter is, the only people who have a reliable opinion, let's think about it like this. With the word value, we have all been in this industry long enough to know that the word value is charged when it comes to who can say the word value and what the value of real estate is, and that's appraisers. We can come up with what a pricing of a property would be as realtors, but we are not supposed to use the word value because that's reserved for appraisers. And the same thing is true with regard to property lines. We can come up with an idea of, well, here's the pin, maybe we can draw a line through it, but a surveyor is the only one who has the professional license that can tell you where the boundaries of the property is. They can do that by physically staking the properties. They can do it by drawing. So if there's any concern of where that property line is, you probably want to, early in the process, because surveyors are far behind, find a surveyor that will go out and identify the corners of the property. That's the cheapest method. The most expensive method, and if you have somebody buying $1 million, $2 million place, it's probably worth it, is to have them go ahead and perform a mortgage boundary survey so that they can determine the bounds of the property and the placement of fences and maybe, sheds and driveways and things like that are on the outskirts of the property line. That is the only effective way to guard yourself against that. But there are other, helpful tools, like Teddy mentioned, just asking the seller and the listing agent, do you know of any easements or encroachments on the property, whether they're memorialized in an easement agreement, if they're reserved in a prior deed, which is another way to create an easement, or if it's just like a known use. Perhaps it's a license where the seller has consistently allowed Bubba's brother to drive his four-wheeler across the property in the back to always get to, the logging road or something like that. So these are things you want to know about, because we know on Blair Avenue over here, there's all kinds of logging roads and you want to be wary of those. Yeah. Oh, one other thing with regard to easements. This is my pointer, by the way.
I like it. Yep.
With easements, we can also create easements. And I'm looking at our attendance today, and I think we have created easements for at least 4 of the people in the classroom today. Easements are generally, for a simple easement, it's $600. As they get more complicated, like with all things, it gets a little more expensive. Easements within the city and platted properties are a little easier than easements as you get far out in the country. And depending on the nature of the easement, one of the things you have to describe in a written easement agreement is the easement area. Sometimes if that's convoluted, we need a surveyor's help to go out there and prepare a legal description for the easement area. So for instance, if it's a crooked stick driveway that is the easement area that somebody has the right to use, that's probably going to need a surveyor. But if it says, you know, the burdened property is going to allow the neighboring property to use the easterly 5 feet of the property line all the way up the property line, then that's something we can describe just between you and I. I can come up with that language, as long as we know that that is going to be the extent of the easement agreement. So the more general it is, the easier it is to do without a surveyor. The more specific it is, more convoluted it is, we're probably going to need a surveyor to help out with that. But the base expense for a survey is $600 plus whatever survey expense might be needed to get that done. And it's something we use quite a bit. As a matter of fact, we had a very involved easement agreement with Andy Allen, and I can talk about this because it's a public record right now on Ordway, where his client, and you guys may have seen this, his listing on Ordway, where his client had 2 lots right beside each other. It was an existing home and an empty lot, and he had marketed them together, but they ended up selling to different parties. The parties who bought them, one was represented by Banker's Title, Rusty Moore's office. The other was represented by Wagon Wheel, and Brandon was the attorney that was on that case. So what we did is the seller prepared the easement agreement, and we had a surveyor go out there and describe the easement area where they were going to have a joint driveway to service both of those properties, the existing home and the home to be constructed. And that's a public record right now. You can, you know, with the right access or a visit to the Register of Deeds office, you can go find it. And that the coordination work that we did is we prepared it. As you might imagine, the seller did not care what that easement agreement said. The seller only cared that both buyers were happy and agreed that the language of the easement was what they wanted in order to buy those properties. And so now they have agreed to that. The easement has been recorded, and we've sold one of those 2 properties, and the other one is in the pipeline right now. So it's a good example, you know, the use of an easement, especially as we get down into the core of Nashville, where, you know, driveways, we have to get creative to get those driveways in.
Yep, yep. Well, this has been spectacular. Thank you for your generous sharing of time. And any other questions? Virginia's putting today, there is a broker open today. Virginia, thank you for promoting that for yourself. At 929 South Street today at 1. It's a gorgeous new build by Jan Walters. It is. That's awesome. Well, Virginia, thank you for sharing that.
I love it. And I've got a shout out to Virginia because her title cracks me up. Virginia loves Rudy title, and we love you too, Virginia. We couldn't do it without you.
That's so sweet.
Yeah.
That broker open is till 1 o'clock. So that's 929 South Street today till 1. I'm sure there's food or something amazing there. So go get you free lunch. Wear a mask. But be out and about, right? Like, spread good love, people. Like, you know, wear your mask, but also, you know, let's not live in fear. But I'm definitely a mask proponent, and I'm taking additional precautions as things are shifting here again. So,
yeah.
We will continue online education. I think it creates great opportunity. I miss being face-to-face, but I love when people at least are daring to put their faces on because, I mean, I have not done my hair, folks. I rolled right out of bed 2 minutes before this started, and yabba dabba do. So I think the first half of the last call, I was porky pigging it, as they call. Yeah, right? Like, you know, all top, no bottom. So whatever you got to do to get to the mic and the video. Sharika, your hair looks good, by the way. What is this? I got to comb it next time. Anyhow, love y'all. Appreciate it. Spread love. Hit the broker open. And next on deck, we've got, just give you all a little highlight. So next week, or what's remaining this week, you have our Thrive call tomorrow at 9 a.m. We'd love to see you there. And then next week on Tuesday, we have the Metro zoning and codes, bill for Metro codes. That should be really interesting. New developments, laws, and things coming from that. So we'll see you tomorrow at 9 a.m. on Thrive Call. We'd love to see you. Bring your video. Don't do your hair. I promise.
Thank you, Ted. Always good.
Appreciate y'all. Thank you.